My name's Sharon Buccino. I'm the director of the Land and Wildlife Program at the Natural Resources Defense Council. We're going to try to keep to the high standard that's been set by the previous panels and have an exciting and engaging, informative conversation. I guess Jason told his panelists they had to be short with their slides. So we are going to have some slides, but we're going to build it into a conversation. And in this panel, what we're going to try to do is really roll up our sleeves and dig into the details of what's happening with the bankruptcies that are shaking up the U.S. coal industry. We're fortunate to have several experts who are on the front lines. But first, I'd like to start with you, Professor Morrison, to give us the basics of bankruptcy law, the basics that we should know as we assess as the process that some of the country's biggest coal companies are going through in bankruptcy, what that means for the nation's federal coal reserves and the communities affected by them. Let me give you a quick introduction while your slides are pulled up there, but if you'd like to go to the podium, Professor Ed Morrison is a professor here at Columbia Law School, where he specializes in bankruptcy law and economics, corporate organization, and contracts. He's also taught at the University of Chicago and clerked for Justice Scalia and also Richard Posner. Thank you.
Well, thank you. I'm going to use this time. I have a lot of slides. I'm going to try to go through them quickly. The goal is just to set a framework for the discussion and bring us all up to speed on how the bankruptcy process operates. And my colleagues here are offering to chime in as I go because, as our moderator said, some of us work at the front lines, and I'm not one of them. And so the people at the front lines will chime in. But the thrust of the slides begin with what is the basic framework of bankruptcy, and then what wrinkles does coal add to the bankruptcy process, or in what ways does the bankruptcy process work a little bit differently when you think about coal? I think and we all basically probably know this, that bankruptcy filings in the coal industry have been fairly stunning. I looked at, it was hard to get good statistics, but last year, one company reported that there were 40 filings in 3 years. By mid-2015, 40 filings in 3 years. By 2016, early 2016, 44% of domestic output is coming from firms in bankruptcy. So you're talking about a huge part of the industry in the bankruptcy process. What's also interesting is just second bullet point, which is that bankruptcy, as we will talk today, is largely, we're going to think about it as a rehabilitative process for keeping businesses going, saving them. And that's usually what we call Chapter 11. Okay, but you can go into bankruptcy just to raise the white flag and shut yourself down. That's called Chapter 7. And 50% of the filings, this is based on the 2015 statistics, but when you look at those 40 filings that were filed in 2013, 14, and 15, 50% of those were in Chapter 7, shutting the firm down. To be sure, those were small firms, but it's remarkable how many firms are just raising the white flag. The biggest filings are out here. We can see them: Peabody, Arch Coal, and Patriot. We're lucky to have Brian Resnick with us, who represented and is still working on the Arch Coal bankruptcy. But what is Chapter 11? So again, I'm going to set the general framework and then look at the wrinkles that coal presents. Chapter 11, as I said, is a rehabilitative process. The goal is to bring shareholders and creditors together to bargain. It's purely a bargaining procedure. Okay? And what we're bargaining over is the extent to which debt has to be written down to make it possible for the firm to survive, and whether some creditors must take a larger haircut than others, and whether some assets must be trimmed back, some operations must be trimmed back or jettisoned, sold, or should assets be abandoned. You can do that in bankruptcy. You can just abandon the asset because it's really a burden to your business. Now, that's the bargaining environment, and Chapter 11 provides a bunch of rules that try to force people to the bargaining table, okay? Encouraging, ideally, consensual resolution, but having sticks and carrots carrots that get people to the bargaining table, and they're going to be sticks that allow you to squash dissent and force creditors to agree to an ultimate bargain that maybe a majority consents to the bargain, a minority disagrees, and that minority can be forced to consent. So what I'm going to do now is just give you some like the basic contours, and then we'll see what happens in coal. So the basics of bankruptcy, three of the things that are key to the bankruptcy process and which enable the bankruptcy bargaining environment are the automatic stay, claims valuation, and asset accounting. So the automatic stay is a key element of any bankruptcy system, and it basically stops all creditors and counterparties, nearly all creditors and counterparties, from pursuing collection efforts against the firm. So the firm gets a breather when it goes into bankruptcy, when it files for Chapter 11. Then we do an accounting. Okay, we have to take stock of the balance sheet. You know, on the left-hand side, we have the liabilities, and a big part of the bankruptcy process is to value what are the claims of the creditors, what are the liabilities of the firm. Of course, this is essential to the bargaining process because we want to know how big of a voice does each creditor have. Are you a secured creditor? Are you unsecured? And what are the values of your claims? Critical is that bankruptcy is a moment in time when everything must be recognized. It's kind of like we call by analogy to tax, it's a recognition event. All liabilities must be accounted for now. All of them, no matter how contingent, how uncertain, how disputed. Even if you think those liabilities will only occur with a 10% chance 40 years from now, we have to account for them now. Because we have to have a process that resolves all of the liabilities in a fair way, so that even people who are owed money now are not systematically treated differently than people who are owed money potentially 40 years from now. All of them must be at the bargaining table, and that's a huge job for the judge, is valuing the debt. Of course, we have to value the assets, the other side of the balance sheet, and the debtor, the concept of assets in bankruptcy is a mixed bag. It's not just your property, the mines, for example, it's your contracts. It may be your hedging contracts, the contracts you use to hedge your input, the price of your inputs, to sell forward the coal to buyers. Those are treated as assets too. So part of the process is to figure out what are those assets, which ones should be kept, and what are they worth. Okay, now once you've done that, we go to the bargaining table. And there are two kinds of bargains that happen in the modern world. There's a traditional one and a modern one. The traditional one looks like this, and it's what you would come away from if you read the Bankruptcy Code, Title 11 of the United States Code, which is that the goal is to put together a plan called a plan of reorganization. The debtor, the firm in bankruptcy, has up to 18 months to put that together. The debtor has the exclusive right to put that together. And what the debtor is going to do is propose what's going to happen to the firm, which assets will be abandoned, which assets will be sold, how operations will be trimmed back, and given the future operations of the firm, which will be described in this plan, what are the payoffs that can be made to the creditors? How much can be paid to secured? How much can be paid to unsecured? Who will get more than others? What you typically do is you put creditors into classes and you announce creditors or shareholders, typically you're going to get nothing. Unsecured creditors, you might get nothing generally too. Secured creditors, junior secured, you might get 50% of what you're owed. Senior secured, you will get 100%, perhaps because we're just going to say, well, we'll just pay you everything we owe you according to the original terms of the contract over the next 20 years. So you basically, a key feature of this is that you're wiping out some claims against the firm, especially the shares, and you're converting other debt to either nothing, or you might convert debt to equity, and then you might reinstate or allow some other debts to continue. But that's the idea, is that you're basically changing the capital structure of the debts of the firm to be compatible with the firm's ability to pay based on its operations. Okay? Once the debtor proposes this plan, the debtor's announcing what's going to happen with operations, what's going to happen to you creditors in terms of your payments, the debtor puts that in a plan and puts it out for a vote. And creditors vote. They vote by class. Hopefully, you get all the creditors to vote in favor. At the very least, you want each class to vote with a supermajority in favor of your plan. We don't have to get into the supermajority rules. They're technical and boring. But there's always dissent, or there's always the risk of dissent. And the Bankruptcy Code provides a mechanism by which, if you have enough classes of creditors voting in favor of your plan, you can cram down the plan down the throats of dissenting creditors. Okay? It's literally a cram down. You can think of pate, for example. So you're going to cram the plan down against, and there are rules by which you can do this, that there are dissenting creditors, and you can cram the plan down. And we can talk about these rules if we want to. They're, again, technical. The famous one's called the absolute priority rule, which just means that senior creditors get paid before junior and juniors get paid before equity. Speaking with a broad brush. Okay, that's a traditional plan, but most bankruptcies don't look like that today in this kind of Byzantine framework, okay? Most bankruptcies look like the first bullet point. They're speedy and they involve a sale, often, usually a going concern sale. I mean, it depends on the year you look at. The statistics vary by year. Some years, half of the bankruptcies look like this if you look at large corporate reorganizations. Sometimes fewer than 50%, sometimes more than 50%, but a large fraction of very large corporate bankruptcies are resolved this way, in which the debtor sells itself to a buyer, sometimes within a matter of months. Think of Chrysler, sold itself to a consortium of Fiat and the federal government within about 30 days. Okay? The firm comes in, sells itself to a buyer, the cash comes in, the cash is just distributed in order of the priority of the creditors, and we're done. Okay? So it's very fast. And that's what people like, because this Byzantine framework on the previous slide can take years. It doesn't have to take years, and that's what goes to the second bullet point. Another modern development is that if you know you don't want to sell the firm to a buyer, you want to keep the firm as is, then you might negotiate what's called a prepackaged plan, which means you go out to your creditors before you even file for bankruptcy and get those creditors to consent to a plan. You say to your creditors, hey, I'm about to file for bankruptcy. This is the plan I plan to propose. Do you like it? What adjustments do I need to make? But then I can file for bankruptcy with the consent of a large number of creditors and quickly get through the process. But the more important and interesting one is this one, the speedy going concern sale. I keep pointing with this pointer, but it doesn't, I don't know if it shows up for you. Okay, so 363 sales in action. So Patriot Coal, in its second round in bankruptcy, has sold itself, virtually itself. I mean, it sold all of its operating mines. There may be some residual assets that remain, but as a mine operator, virtually it's selling itself in its entirety to two buyers, Blackhawk Mining and the Virginia Conservation Legacy Fund. And basically, most of the action in Patriot is being resolved through this sale. Arch Coal has sold not itself, but a part of itself. And that's another feature that Arch Coal, and Brian can talk about this as well, that it sold a stake in an export terminal, but my understanding is that, I guess, are we headed towards a traditional reorganization in that setting?
In fact, we are, Ed. I think probably the second one we've seen in the large cases in the coal industry, the first being Patriot 1, which filed again 18 months later, so I guess it wasn't a successful reorganization. But that was a reorganization. Arch Coal is going to emerge probably this month, where its creditors, its secured creditors, are equitizing their debt and will become the owners. You know, it's actually these two ways of looking at things, the reorganization and the 363 sale, interestingly, in the coal industry, are not that different from each other. Because when you look at the Blackhawk Patriot deal, for example, and this is what Blackhawk actually did with James River. We represented James River coal as well. So using that one as an example, Blackhawk actually bought James River's assets with debt financing. And so the creditors of James River, rather than effectively kind of owning a reorganized James River, they ended up owning debt in Blackhawk. So Blackhawk did not actually pay cash. They paid some cash that was actually provided by James River's lenders, so it was just kind of round-tripped. So unlike in some cases where a healthy buyer with a boatload of cash will come in and simply pay cash and cash out the creditors of the debtor, in the coal industry we're seeing we're seeing basically debt-financed, seller-financed acquisitions. And the other type of acquisitions we're seeing in the coal industry are basically negative purchase price acquisitions. For example, when we sold most of the good mines of James River to Blackhawk, we also sold the other mines to Revelation, which did not pay a positive purchase price. They basically took it on for the reclamation, and they also got the right to any return of collateral once the reclamation was performed.
And that describes also the acquisition by the Virginia Conservation Legacy Fund.
And before we get too far into the conversation, for the audience, let me just introduce the three other experts that we have on the panel. So Brian Resnick is a partner at Davis Polks in their insolvency and restructuring group. He is a graduate of Columbia Law School, and he is representing Arch Coal, and you mentioned James River Patriot as well in those proceedings. But I have to say I was most interested by the fact that before you went to law school, you actually trained at Juilliard as a percussionist and played on Broadway and on Saturday Night Live, right, with Tina Fey and Rudy Giuliano.
That was during my 1L year here at Columbia.
Oh, okay, very good.
Yes, I had to justify to Jimmy Fallon why I was actually going to law school.
So thank you for being here. And then we have Anna Zubitz Anderson, correct? With Moody's Investor Service, and is a vice president there, a senior analyst with 15 years experience in credit analysis, securities litigation, and public accounting, and a certified CPA, correct? Yes. And Peter Morgan is an attorney with the Sierra Club out of the Denver office and is representing the Sierra Club in several of the bankruptcy proceedings, including Alpha, Arch, Patriot, and Peabody as well.
So with that, why don't we turn to thinking about the wrinkles relevant to the coal
If I can
industry?
just jump in,
Oh,
because
sorry.
I think there's one thing worth pointing out on the previous slide, which is the VCLF transaction was not how Patriot originally proposed their plan. Their original proposal was all of the assets that ultimately went to the Virginia Conservation Legacy Fund, which is essentially originated as a land trust. They were proposing that those would all go to a liquidating trust, where a liquidating trustee would oversee a process of essentially abandoning those properties which had enormous environmental liabilities. And we saw a similar proposal in the Alpha Natural Resources bankruptcy earlier in the process. Ultimately, they didn't go with the liquidating trust there either, but the threat of that liquidation hung over both of those bankruptcy transactions, and I think really ultimately dictated the outcome, and particularly dictated the role that the federal and state mining regulators and other environmental regulators were able to play in those bankruptcies, given their desire to avoid that liquidation and abandonment scenario.
Okay, great. Well, that's the perfect segue to, I want to talk now about what is, when you apply this framework to coal, what are the interesting things, the complicated, the difficult questions that arise that generate conflict among the actors in the bankruptcy process. And so I'm basically just going to go back to each of the points I've talked about before, the automatic stay, claims valuation, and the rest, and show how each of those change in coal. So let's start with the automatic stay. Like I said it stops nearly all creditors and counterparties from pursuing action against the firm in bankruptcy, but it doesn't stop the government, okay? And that makes a lot of sense, that there's a so-called police and regulatory authority exception to the Bankruptcy Code's automatic stay, and so it doesn't stop the government from obtaining an injunction to force cleanup. There's a nuance here that if the statute does not permit a suit for compensation, just requires that the agency seek an injunction, that order, that cleanup order, that survives bankruptcy. Okay? Remember the goal of the Chapter 11 process is that you're wiping out equity, wiping out some debt, writing down other debts, and you're getting a new day. Well, there's some obligations that you cannot get rid of. They're going to hang over the land, hang over the firm, even after the bankruptcy. Okay? Now, of course, sometimes the government will do the cleanup itself because it's a matter of urgency, for example. And if the government does it during the bankruptcy process, that debt can be wiped out in bankruptcy, but it gets priority. So this is a controversial feature of the Bankruptcy Code, but governments who do cleanup before the bankruptcy and during the bankruptcy, the debts owed for that cleanup can be wiped out in bankruptcy. There are different priorities that debt can get, but it potentially can receive very little in bankruptcy. We'll skip this last bullet point. It's a little more technical. Claims valuation. Okay, remember I mentioned to you that it's a day of reckoning, the bankruptcy filing, and we've got to make sure that all the relevant parties are here, even parties who might have highly contingent claims that might arise 40 years in the future. Well, that means in particular that the bankruptcy court has to estimate future cleanup costs, even if no cleanup is required yet. The government's got to estimate, the bankruptcy court, with the help of the parties, must figure out what is the potential cleanup cost generated by this mining operations. And that can be a very error-prone process, and it might require the setting up of a trust, that, in some sense, that the bankruptcy process might yield the creation of a trust into which funds are put, and those funds are just set aside for the future to deal with remediation. And we're just hoping that they're sufficient. Some liabilities, however, are so uncertain that the court will refuse to value them. Okay? And this is something that we call the problem of future victims. Example, years from now, solid waste may leak from a storage container, contaminating drinking water and harming people. What are the rights of those people? You know, most courts would say that, well, they have suffered no harm. There's nothing, the firm today has done nothing wrong. It has put its waste into storage containers that we think won't leak, but there's still always a risk they might. What happens if they do, and in the future victims are harmed? What rights do they have? Well, most courts will say, well, those victims, their claims are so uncertain. We know they might arise in the future, maybe with some, we could say with some probability they might be rise with 0.5% probability that these victims will arise in the future. But because it's so difficult to measure the claims of those future victims, we're not going to recognize them in the bankruptcy process. That's good and bad. It's bad in the sense, well, they're going to have no seat at the table. I mean, we could appoint an attorney to advocate on their behalf right now, but we're not. What we're going to do instead is say that in the future, these victims can sue the successor. They can sue who bought this firm, who bought the land, things like that.
I will say on that first point, it is one of the interesting things about these coal mine operator bankruptcies is there's already a process in place under the Surface Mining Act to provide an estimate of what those cleanup costs are, because the way the Surface Mining Act operates is a coal mine operator is not allowed to move a shovelful of dirt at a mine until they've posted a reclamation bond, which is supposed to be sufficient to cover the cost of the government or another third party coming in and carrying out all of that reclamation. So the companies have a regulatory process where they've already estimated those cleanup costs. Now there's two wrinkles to that, though. The first is there's a fight over the mechanism for the set-aside to make sure that those costs will be covered coming out of bankruptcy. And I think one of the really interesting questions in these recent coal company bankruptcies is the role of self-bonding, which is for a lot of these bigger companies, before going into bankruptcy, they were allowed to, as opposed to getting a third-party bond, a surety bond, for that reclamation liability, they were allowed to self-bond, meaning the regulators looked at their balance sheet, said they're unlikely to go bankrupt, they don't need to post a separate bond. Well, of course, now they're in bankruptcy, and the question is, how is that going to be addressed? And then the second interesting wrinkle is that reclamation bonding does not account for some additional future costs, which probably do fall into that column, which is the water treatment costs. A lot of these mines create an enormous amount of water pollution, particularly the Appalachia mines. And the costs of treating that pollution have been estimated in the hundreds of millions of dollars. And so those are future costs that certainly we think need to be fully accounted for in the bankruptcy process.
Yeah, we dealt with that in Patriot together. There was over $400 million of estimated selenium costs, and we were able to work something out where we were able to delay the cleanup a little bit in the hopes of having more efficient cleanup mechanisms kind of lower that cost. But you know, it was an interesting case where, I mean, bankruptcy is all about, it's very interesting from a policy perspective to see how the different very important goals get weighed, and got weighed by Congress and get weighed by courts. It was a perfect example. While, you know, at the same time we were dealing with the very unfortunate cutting of medical insurance, and health insurance, and pension payments to retirees. We had to cut the medical payments by over $1 billion to very sympathetic retirees. We were also at the same time having to preserve the right to clean up the selenium, which, at least my understanding was, it didn't have an effect on humans. It's bad for the environment, bad for fish, but not for humans. And so we had a lot of creditors and investors in the case who were, and other parties who were really trying to see whether we could divert funds from the selenium cleanup to the retirees, and we just, under the law and the legal standards, we just weren't really able to do that.
So let me touch on two more things and just step down so I don't take up too much time. And they both take a riff off what was just what has been said before. It was mentioned that that in the case of Patriot, that there was I think you said that prior to the transfer of the mines to VCLF, there was discussion of abandoning mines. So there's a concept called abandonment under the bankruptcy code. Assets may be thought to be burdensome and of inconsequential value. Think of land that's subject to toxic waste, where it has some environmental hazard on it, and it costs more to clean the land than the land is worth. Well, that's a pretty inconsequential value to the estate, and it's burdensome to the estate, meaning the firm itself. Very costly to the society, but to the firm itself, it's of inconsequential value and burdensome. And one of the long-standing strategies is to try to just abandon that land. It's permitted by the bankruptcy code, and abandoning means basically like leaving something on the street, okay? Plausibly, many coal properties can fall into this category. And worse than that, Supreme Court has given us a pretty confusing rule about how to think about abandonment in a case called Mid-Atlantic from the early 80s, I want to say.
86, I think.
86. Said that, in that case it said you can't abandon land in violation of environmental laws where there's a risk of imminent harm to the public, okay? Now it kind of seemed, on one hand, it said the Supreme Court was saying you can't abandon property in violation of environmental laws, but then the court had a lot of dicta saying because that would harm the public. It would be, that kind of abandonment would pose imminent harm to the public. And so that's led to a split among the courts about, well, when can you abandon, say, a coal mine? Some courts say you can never abandon it if that would be in violation of federal environmental laws. Other courts say we can abandon it as long as there's no imminent harm to the public. So there's this uncertainty about what can happen. And I don't know how that tracks by jurisdiction. Maybe you do, Brian.
Yeah, and look, as a bankruptcy lawyer, what we would love to have been able to do would be to basically let the sureties hold the bag, because all the reclamation was bonded, and the bonding companies only had a certain amount of collateral. Industry average was probably 20 to 40% of collateral. So if the debtor, the bankrupt company, were to maybe file certain mines for Chapter 7 or abandon them, then the sureties would be on the hook for doing the cleanup, and they would have a secured claim back against the estate for only 20 to 40% of the amount of the cleanup. I think the main problem we ran into was permit blocking, that both the managers and people running the business basically could have been permit blocked, meaning that they couldn't get permits and continue to mine the good mines. And asset purchasers didn't want to deal with a company that was abandoning some mines and not others. I think they thought that they were going to run into too much regulatory trouble, so we weren't able to effectuate any of those. But believe me, for Patriot 1, where we had some mines that were totally underwater, and those were the heavily unionized mines where the union contracts were bad. If we were able to do like a good co, bad co thing and take the good co entities and reorganize around those and just sort of flush the that's not a technical term, but flush the bad co's, it would have been sort of a bankruptcy lawyer's dream, but it just doesn't work that way.
And there was another issue with that approach with Patriot, which is all of those high liability, high treatment cost mines are in West Virginia. And in West Virginia, the company's reclamation bond only represents a fraction of the actual reclamation cost. So even if the sureties had paid out 100%, the state of West Virginia would be on the hook for the majority of those reclamation costs. Now, West Virginia makes up that shortfall through something called the Special Reclamation Fund, which is a pooled bonding approach, which is financed through a tax of 28 cents per ton on every ton of coal mined in the state. The problem is that fund now stands at $78 million, but the reclamation liability for just Patriot alone exceeded that amount. And obviously, Alpha has a number of mines in the state. Other companies in bankruptcy or close to bankruptcy have reclamation liabilities in the state as well. And so one company going down, zeroing out that fund, means that the West Virginia taxpayers are then on the hook for all the remaining reclamation. And so the question then is, do they avoid doing the reclamation, or do they put an even greater financial burden on the rest of the state? So again, I think we're seeing this tension between the way the Surface Mining Act was intended to operate and trying to avoid some of these issues of unfunded reclamation. And then the tension between that and what the bankruptcy code allows, and the assumption that that the whole Surface Mining Act scheme is based on, which is you're never going to see the sort of secular decline in the industry that we're observing now. And I'll stop in a moment, but obviously this all, we're talking about a company, Patriot, which did have surety bonds for all of its bonding responsibility. It's an even harder question when you're talking about companies like Alpha and Arch and Peabody, who self-bonded for all or the vast majority of their reclamation liabilities.
And I also want to make clear that this discussion does not hinge exclusively on the ability to abandon. Even if a company does not abandon a piece of property and it holds on to that mine that's needs dramatic remediation, that doesn't mean it gets remediated. The company may still have insufficient funds available to do the remediation, in part because the costs of remediation, you have to think about those. What priority do those costs have relative to the other debts on the corporation? Secured claims will be paid first out of available collateral. So you could have banks being paid out of other collateral, leaving very little left in the firm to pay for the remediation of the land. So whether you abandon it to the public, and the public may have to undertake the remediation, or the firm keeps it, even then when the firm keeps it, there might still be a public duty to remediate, because when the firm shuts down, the available cash has been paid out to higher priority creditors, and there's nothing left for the remediation. Let me just do one last wrinkle, and it goes to what Brian just mentioned, which is dealing with labor rights. One of the most important features of the bankruptcy code is the ability to reject collective bargaining agreements. It's pretty a remarkable feature, because outside of bankruptcy, no employer can breach a collective bargaining agreement. The employer must go through the collective bargaining process, must work with the National Labor Relations Board to modify any existing CBA. But bankruptcy changes all that. And there are two sections that are relevant on the bankruptcy code, 1113 and 1114. 1113 allows a firm in bankruptcy to terminate its collective bargaining agreement or to modify it. 1114 allows the company to terminate or modify pension obligations and other post-employment benefits. There's a complicated process for doing this. It's a negotiation process. The ultimate standard that the court applies is whether modification or termination of the collective bargaining agreement is either necessary to complete the reorganization more successfully, that's the Second Circuit standard, or necessary to avoid liquidation, the Third Circuit standard. So the different standards, and it's thought that the Second Circuit standard might be a little easier to satisfy.
So you almost never see labor cases in the Third Circuit.
So instead of, the process looks like this. Maybe I can give you just an example from Patriot Coal. When Patriot Coal filed its motion to terminate its collective bargaining agreement, it said to the judge, look, here's the process I've gone through. It's time to terminate. On November 15th, debtors made their original proposal to modify the bargaining agreement. On January 8th, the union made its first counterproposal. On January 17th, debtors provided the second proposal. On February 5th, the union made its second counterproposal. So you can see that there's proposal, counterproposal, proposal, counterproposal, until you get to the fifth proposal by the employer. And this is the typical negotiating environment in which the firm is supposed to make a proposal for modifying benefits, wages, and the like, giving the union lots of information, and the union makes a counterproposal until you reach a point where there's no agreement possible. And the judge has to decide at that point, did the union reject without good faith or without good reason for doing so? And would termination of the agreement satisfy one of these two standards, necessary to complete the reorganization or to avoid liquidation? in this presentation, I've spoken with a very broad brush. I'm going to leave it to my panelists to fill in some more details because even this area of the bankruptcy code is incredibly complicated.
Yeah, look, I mean, my sense, I mean, as you might know about bankruptcy, debtors can reject any contract except for collective bargaining agreements, which have a higher standard for rejection. My sense is that when you negotiate with union leadership, they're very smart people. They really know what's going on, and I think they have a good sense as to the labor cost structure that the company can sustain. I think that the union membership is very resistant, understandably, is very resistant to change and to agree to anything. And I think in the real world, you kind of need the judge to basically order. In most of these cases, it's very hard to reach an agreement and reach a settlement prior to the judge ruling on the 1113, 1114 motion. I think you just kind of need that to happen. So it's a very long and extensive and expensive process, unfortunately, for these companies to go through the 1113, 1114 process, but it seems to be necessary. In that case, we won it hands down. In many cases, the judge will get pretty detailed in what cuts they think you need, what cuts they don't think you need, and they'll say, you know, you lost debtors, but if you make these 3 changes, then you'll win, and then that sets everybody into the hallway to really cut a deal. In Patriot, we just sort of won hands down, and the union, they were going to appeal, and they always maintain the right to strike, which is another interesting part of the dynamic in 1113, 1114. It's not true in the airline industry. So in the airline industry, when we represented Delta Airlines, and when we won 1113, 1114, that was like a real win because the pilots couldn't strike. In the coal industry, you can go through a months-long, very extensive litigation and win it as the company, and then the coal miners can say, all right, fine, but we're going on strike. So we ended up settling with them after we won, basically settling their appeal.
Great. Thank you. Thank you, Ed. That was fantastic. Brian, I'd like to just pick your brain and experience to address one of the issues that is key to kind of the policy debate and decisions that have to be made going forward, and that's if you could address the form that you see the companies emerging from bankruptcy, and also, you know, who are the new investors that are coming in and why?
Sure. Well, in a lot of these cases, they're pretty large distressed hedge funds that are in a lot of these cases. I went and took a look at yesterday in preparation for this at sort of all the 2019 statement. 2019 is the rule that requires investors to under certain circumstances to publicly file kind of who they are, and the ones we're seeing in multiple cases like Whitebox, Highbridge, Centerbridge, Oaktree, and then there are a whole bunch of other large distressed investors in sort of each of Peabody, Alpha, Patriot, Walter, et cetera, and I think they tend to wind up with a huge ownership stake in the reorganized companies, even in those that are kind of sales like the Blackhawk type sales, then they end up being debt investors. Some of these companies are emerging as public companies, in which case once they own the company, it's a public board, and these investors do not play an active role. And other times, sometimes the investors do have representatives on the board. So it really sort of runs the gamut. And then you have the Blackhawks, and you have the VCLFs, the sort of more strategic parties.
Thank you. And the next panel is going to really dig down into the legal obligations related to workers and to the land reclamation. But if you could just give us a snapshot of from the trenches, really, in terms of how you see some of that playing out.
Yeah. So, you know, the most common question I always get from investors is, what priority is reclamation? And I think that is, it's a complex question to answer, because if you open the bankruptcy code, you don't see reclamation there. You do see 28 U.S.C. 959B, which requires compliance with laws, so that says that a debtor in bankruptcy has to comply with laws. But under technical legal priorities, a government claimant or a surety bond party that has a claim on environmental obligations, it generally speaking does not have priority. But that said, Most of the time, buyers, all the time when you reorganize, you're going to assume all your environmental obligations, and the buyers will assume it for the reasons that I discussed, and buyers are going to take into account when coming up with the purchase price. So when a first priority secured creditor is saying, how should I think about these types of obligations, I say you should think about it as if it comes ahead of you, because as a practical matter, it most likely will.
Peter, let me turn to you and just get you to give us a sense of how the Sierra Club has gotten involved in these proceedings and why.
Sure. So our first foray, my first introduction into bankruptcy was in the Patriot II bankruptcy, and that was largely because of what we've touched on, which is the existing water treatment obligations that the company held. Those were secured through settlement of federal Clean Water Act enforcement litigation that we'd brought, and so we started participating in the bankruptcy in order to protect those obligations, to make sure that as the company emerged from bankruptcy, they wouldn't be able to have those treatment obligations discharged or otherwise get out from under them. Of course, Patriot II was followed by Alpha and then Arch and Peabody. And I think as we got involved in the bankruptcy process, we did see the absence of a voice talking about these treatment and reclamation obligations going forward. And I think particularly, in the next one out the gate, Alpha, there we really did see the influence of the self-bonding that I've referenced. Alpha had about $650 million of purely self-bonded reclamation obligations. About 440 of that was in Wyoming, and about 211 was in West Virginia. Again, Alpha, had this proposal to split in two all of its most valuable assets, what the government attorneys called their crown jewel assets, primarily the Powder River Basin mines and some deep mines in northern Appalachia, would go to a new company formed by the lenders. All of the high liability mines, primarily in West Virginia, were either going to be transferred to a liquidating trust or left with what we saw as an underfunded, reorganized Alpha. And we had significant concerns about what would happen with those mines left behind in West Virginia. I really think that in many ways, self-bonding is the story of these bankruptcies, particularly Alpha, but also we're seeing Arch, and I think we'll very much see in Peabody. And Alpha resolved. The plan has been confirmed. It was based on sort of last-minute settlements where state and federal regulators and Sierra Club and our environmental allies reached settlements with Alpha, essentially requiring the company to set aside dedicated funds of money for meeting their mitigation, their reclamation, and their water treatment liabilities. But it's far from a perfect deal. Alpha is being allowed to self-bond in West Virginia at the mines that will be continuing to undergo reclamation, where those obligations are valued at $155 million. Now, they'll be required to replace those, but it's over about a 20-year time frame. So at the point of most danger of a second bankruptcy, the first few years, there's essentially no bonding available there. And I really think that the regulators and the environmental interests, because of that self-bonding, are in a position where we're negotiating with a gun to our heads, because the threat exists of abandonment through liquidation, where all of those costs get pushed to the regulators. And again, if that's $155 million in West Virginia's total for every mining operator in the state has only set aside less than $80 million. That's a huge hit to the state. So they're desperate to avoid that. And at the confirmation hearing in Alpha, the Department of Justice bankruptcy lawyer representing the Office of Surface Mining and EPA stood up and said, effectively, this is the best deal that we could get given the threat of Chapter 7 litigation. So he wasn't saying, or liquidation. So he wasn't saying this is a good deal in absolute terms. He was saying, as opposed to this catastrophic alternative, we're going to let this go and keep our fingers crossed that they can actually pull off what they're proposing. Now, we were pleased to see in Arch that Arch did just commit to replace all of its self-bonding in Wyoming, which I think is a really important and good step. We haven't yet seen a plan from Peabody. They have over $1 billion in self-bonded reclamation obligations, but we're hoping that they'll follow Arch's lead and replace that as well.
Great. So we could go on for a while. I do want to leave some time for a few questions from the audience, but I want to give Anna, you a chance to explain how a credit rating agency goes about looking at these companies and in the context of bankruptcy. Okay. And you have a few slides, correct?
Yeah, I do have a few slides. I probably have too many for how much time we have left, but I'm going to try to zoom through. Okay, so this is a slide that just summarizes, what we've seen in the past 2 years. As you can see, what we've seen is that most key coal players that we rated actually filed for bankruptcy in the past 2 years. That's about 20 billion in debt that's either going away or becoming much smaller. And we're just now obviously seeing some of these players emerge. This is just the ratings trend over the past 2 years. As you can see, we've been doing a good job and managing these ratings down. An average rating has gone down from B2 in 2014 to CAA3, which is very, very deeply spec grade early this year. This is the winners, I guess I should say. These are the remaining coal companies that have not filed. As you can see, these are very lowly rated companies as of now. This is very much a spec grade portfolio. Most of these companies, other than the top two, most of these companies are actually small players. So interestingly, what we've seen is that the ones that hung in and did not file were sort of niche players that had special kind of situations going for them, either good contracted positions or geographical advantages, things like that. So we have not had the privilege yet of rating some of these companies that are going to be emerging from Chapter 11 process. Hard to say what they're going to be rated right now. I haven't really seen them in detail. But given the slide, you can see how low the ratings are. Obviously, expectation is that whatever is emerging is probably going to be fairly low rated too. So that brings me into the next point that from the rating agency perspective, our outlook on the coal space remains negative. And the previous panel, you heard a little bit about some of the positive developments that are happening in the space, but really, the way we see it is that the revenues are still declining, the earnings are still declining. Coal companies are operating under long-term contracts. We're still seeing these long-term contracts roll off with higher prices, so the average prices at which they sell their coal is still coming down. And really, over long term, we see coal industry as being in secular decline. So there might be short-term positives, but over long term, we see the coal industry in secular decline, and that's low-price natural gas, which plenty of people commented on. It's weak metallurgical coal markets, and it's obviously regulatory pressures. I'm going to skip over some of these details in the interest of time. This is kind of a good slide. This is EIA data, good data from EIA. But you can see, this is a very rapid decline in the coal space in a fairly short period of time. That blue line that you see is the percentage of fuel mix, the coal share in the U.S. fuel mix. And you can see it coming down from about 45% in 2007 to something like 30% this year. And this is the year where, for the first time, we're going to have natural gas actually overtake coal in the fuel mix in the United States. So it's not king coal anymore. It's going to be king natural gas now. And from our perspective, really, that's what we expect to continue over the longer term. So that's certainly going to keep the pressure on the ratings for the emerging coal companies and existing coal companies that we rate. Regulatory pressures are a key issue for us. As I said, there are many factors that are driving our negative outlook on coal industry. It's weak steel production worldwide that's depressing metallurgical coal markets despite the recent spike. We don't think that's going to be sustainable. It's low natural gas prices that we see continuing. But we also see the way we view regulatory environment is that we see it as something that's just going to keep a cap on coal's recovery. In other words, the way we see it, even if prices were to improve, if natural gas prices were to increase, even if there are short-term fluctuations that are positive in metallurgical coal markets, we see the regulatory environment as something that's over long-term will keep coal in secular decline. So that's going to keep pressure on the ratings. We've been talking quite a bit just now about reclamation obligations, and it's certainly a big concern for us, and it's something that we're watching. And the concern from our perspective is that we're seeing coal companies that are going to be emerging with smaller footprints, lower revenue base, lower earnings, and they're closing mines. So while their footprint and scale is declining, their reclamation burdens for the mines that they used to have and are now closing is actually going up. So it's obviously a problem. You have reclamation obligations growing for an industry and companies that are actually contracting. So we definitely see it as an issue, and we've talked a little bit about this. The previous panelists have mentioned it. But often these things effectively wind up taking priority in bankruptcy, so they're reducing recovery for other creditors. So as a credit rating agency, from our perspective, they're certainly negative for the credit. One of the concerns is if the assets get sold, these reclamation obligations can significantly decrease asset values. We've seen several asset sale transactions recently where the seller of the assets actually had to pay the purchaser to get rid of the assets because the reclamation burdens were that high. Self-bonding is an area that we see, is an area of change, and from credit rating perspective, it's an area of concern for us. Prior to this recent wave of bankruptcies, we saw companies be mostly self-bonded, which basically means they didn't have to post collateral to secure their reclamation obligations. And that is changing. As they went through bankruptcy, they had to post collateral. As they're emerging, we see them having to post collateral. We think in the future they're going to have to post more collateral. And from credit perspective, that's a concern for us because that's going to cut into liquidity that they might have available for other purposes. One of the things that we're also noticing is that asset retirement obligations that are reported on the balance sheet. I'm not going to go too much into the weeds with that, but the asset retirement obligations typically are, they don't really fully reflect the liquidity risk that these obligations represent. I guess I'm just going to say that in a short way. So to sum it up, what do we have emerging? We're going to have a smaller, leaner industry. We're going to have players emerging from Chapter 11 process with much less debt. Those that have not gone through restructuring process will be at a disadvantage because they're going to be competing with leaned up companies that have cleaned up their balance sheets. And other players that have not done so will have their legacy debt outstanding. And so the industry, we see it again as being in secular decline. And it's kind of an evolving story. And that's all I have.
Thank you.
For my remarks.
That's great. Thank you. So we'll take 5 minutes for questions. Okay, we've got a number. Do we have the microphones? I don't see microphones. Okay. Here. Put this one off.
They're right here.
Okay. Give one over there, Michael, if you would, and we'll start over here, too. Go ahead. You've got the microphone, and let's come over here. And identify yourself, please.
Hi, my name is Mark Gold. I'm from Newmark Capital. And I have a question with regard to the Patriot transaction and looking forward at the number of companies that are coming out of bankruptcy. And the question really is directed at Brian and at Peter. From a post-mortem perspective, you had Patriot come out of bankruptcy in 18 months, go back into bankruptcy. From a senior lender's perspective, what's the postmortem that you draw from that? What are the lessons to be learned clearly with
Yeah.
regard to the next generation of restructurings?
I mean, look, coal is a commodity. I mean, now I'm dealing with a lot of oil and gas cases as well, where investors at the end of the day are really making a bet on the commodity and on the timing of it. And I think Knighthead and others who basically backstopped the rights offering, and other investors who participated that in Patriot One, I think we're really making a bet on a quicker turnaround than happened. And it just sort of didn't work out. I mean, I think in many of these situations, there really is kind of a lot of option value. If we do see an improving commodity market, as has happened recently, I think a lot of these will work out. But they kind of that's the kind of bet that I'm seeing.
My take on it is it should be the source of concern in looking at the prospects of VCLF and its ERP compliant fuels coming out of Patriot 2, and the ANR Inc., which is what's coming out of Alpha with the high liability assets. Because one version of the story of Patriot was, prior to that first bankruptcy, Patriot itself had been spun off of Peabody, had acquired some assets from Arch that themselves were very high liability, which is essentially what we've seen with what VCLF took on and with what ANR has taken on. These very high liability assets, allowing the other companies spun off to retain the high value properties. So I expect that one or both of VCLF and ANR will itself be back in bankruptcy, just like Patriot was.
It's important to keep in mind that this is not unusual. In declining industries, it's very common to see repeat filings. You saw it in airlines. I mean, a lot of companies you've heard of, Sbarro has filed for twice. It's a very common phenomenon to file twice for bankruptcy, in part because you're gambling on how far the industry is going to fall before it rebounds.
Yeah.
Right, it's so common, it's referred to as a Chapter 22.
Yeah.
Trump
go to
has,
the
I
next
think, a
question.
Chapter 55.
And that actually relates to that relates to my question, Larry Shapiro with the Rockefeller Family Fund, and maybe this is more for Moody's as a neutral observer here, but than anybody else. But the first time around didn't work for Patriot. I don't know if this is going to work now. And listening to what we've heard today on this panel and earlier, the market share seems like it's declining for coal. The commodity price seems like it's probably going to stay down. The reclamation burden will not be entirely shed, and they're no longer likely to have the option of self-bonding, so they're actually going to have to pay for bonding in some ongoing way. I guess I'm just wondering how likely it is, do you think, for the companies that do emerge from bankruptcy to remain out of bankruptcy as we go forward the next few years?
Can I take that?
Go for it.
I guess the key companies that are in bankruptcy now. So Alpha just emerged, and then we've got Arch, Peabody. The way we see it is that those are the companies actually with better assets that are now going to have much stronger balance sheets. And yes, they're going to have a lot of challenges, but up against other smaller players that had not gone through the process, or even if they did, we still think that those are going to be put at an advantage. And yeah, we're going to have a declining industry, but we really think that this is going to be a much, much slower secular decline than sort of a drop that we had in the past few years. So I guess I think that for the companies that are going to come out, with their minds and restructured balance sheets, even though the industry is declining, it should be manageable for them. It's hard to say. Like I said, we haven't rated these new entities yet, so it's something to be watched.
So let's take one more question from each side, and we'll just get them both out on the table.
Hi, I'm Janie Hine from the Institute for Policy Integrity at NYU Law School. My question is, I guess, mostly directed at Peter, and that is, I was wondering if you could speak a little bit more to the future of self-bonding. I know that the Office of Surface Mining and Reclamation recently issued guidance to regulators and state regulators, encouraging them to exercise their discretion to deny requests and applications for self-bonding, but they're somewhat limited by the statutory language in terms of, altogether abolishing self-bonding. Can you speak a little bit about, what you think we'll see in terms of companies continuing to self-bond and what you would like to see and think might be achievable from a policy change perspective?
Okay, and let's just get the second question out on
Sure.
the
Russell Schimmer,
Yeah.
Science Global. I'll dovetail on that one. We're talking, there is this push obviously towards this third-party bonding, financial assurance to cover what is no longer so popular in self-bonding. But the question I have is, where's the capacity for that? That has to have a capacity in the sense of the underwriters or the underwriters who can actually take on these environmental bonds have to be willing to take on that amount of money, the amount of money that's now being pushed out of self-bonding into third party. And I'm wondering whether anyone has any comments on whether the actual underwriting industry, that capacity actually exists. That's my question. Thank you.
Okay, great. So Peter, why don't you address the self-bonding regulatory issue first?
Sure. It's a great question, and I think the answer has two parts. The first is, even before we saw any proposals from the Office of Surface Mining, we already saw some companies voluntarily transitioning away, Cloud Peak being the most notable example, which in May committed to replacing all of its self-bonds. And I think it did that for economic reasons. So I think kind of the writing was on the wall. In terms of the regulatory changes, you referenced the guidance that the Office of Surface Mining issued, which was accompanied by a pretty forceful statement from OSM Director Pizarczyk. They've now followed that up, and they're also very shortly will be publishing an advance notice of proposed rulemaking to actually modify the self-bonding regulations themselves. I've heard the argument that you sort of flagged, which is self-bonding's in the Surface Mining Act statute, and so OSM can't entirely eliminate it through guidance or rulemaking. That's true that it's authorized by the statute, but the statute and the existing regulations are also very clear in that they give the regulators total discretion in whether or not to issue a self-bond. And the existing regulations set out a series of financial criteria for whether a company qualifies for self-bonding. And those are obviously, or were misguided because they didn't prevent the crisis we're seeing now. So I think what we'll see is a real tightening, which combined with the discretion in the regulators, I think and I hope, means that it will be incredibly rare, if at all, that a company is able to satisfy those criteria. And really it goes back to, the heart of the Surface Mining Act. It was passed in 1977 to respond to what was seen at that time, which is abandoned mines, across the landscape. These reclamation and reclamation bonding requirements are at the heart of the statute. And so I think the regulations need to come in line and recognize that reality and make sure that there actually is money to back it up, which tees up the second question, which I don't...
maybe, I don't know, Brian or Anna, you may have
Yeah,
a sense
we
of
are
that.
finding that there is capacity. The real question is how much collateral are they going to require?
Yeah.
Remains to be seen.
Yeah, I mean, we are seeing that surety bonding is becoming more expensive, right, and less available.
Mm-hmm.
Good.
But it's a big liquidity hit to these companies who are emerging who have to post a high percentage of collateral.
Yep.
Well, great. Well, with that, we'll end, and let's thank the panelists. Thank you very much.